Good afternoon, and thanks for joining us for a Tax Practitioner Board webinar. My name is Ashley Dowsard, and I'm hosting today's session. Today, I'm joining you from Ngunnawal and Ngambri country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters, and community. I'd like to pay my respect to them and their cultures and elders, past and present. To begin, I have some quick housekeeping messages. First, to access today's slides, you can visit our webinars resources hub at tpb.gov.au/webinar-hub. We'll also email you a copy following the webinar. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we'll issue an attendance certificate to those of you staying online for the webinar today. Today's presentation will help you understand the whistleblower laws and how your new breach reporting and false and misleading obligations work together with the laws. We're also joined by the ATO, so you can gain a shared understanding of the actions required if you need to report a client or another tax practitioner to the ATO and/or the TPB. We'll unpack the whistleblower laws from an ATO and TPB perspective, including who are eligible whistleblowers and how you would qualify for protection. Information you can disclose and how to make a disclosure to the ATO and TPB, including voluntary disclosures, breach reporting obligations, and how these obligations interact with the whistleblower provisions, false and misleading statement obligations, and how these obligations interact with the whistleblower laws, reporting false or misleading statements to the ATO, confidentiality obligations. To finish up, we'll answer some of the questions we received during the webinar, so make sure you submit your questions via the Q&A. In that regard, we have Fiona and Kristen from our policy and legislation team, and Matt and Kelly from the ATO joining us to respond to your questions as we go. To find the Q&A, simply hover your mouse over the screen and a range of icons will appear at the bottom of your screen. You can also use the chat function to speak with other participants. However, we won't be monitoring the chat closely throughout the presentation. So if you need a response from us, be sure to use the Q&A. To disable any of these functions, simply hover over the relevant icon and unselect Show Preview. I'd now like to introduce our speakers for today. From the ATO, we're joined by Diana James, Director of the Information Disclosure Team and Tax Whistleblower Unit, and TPB Assistant Secretary Peter Coit. Let's start with you, Diana. I'll now hand over to you to get us started.
Thank you, Ashley. It's great to be here, and I'd like to extend a warm welcome to everybody joining us today. It's a pleasure to be here today alongside our partners in the Tax Practitioners Board to talk to you about the whistleblower laws and how your new breach reporting and false or misleading obligations work together with those laws. So as stated, my name is Diana James. I'm the Director of the ATO Whistleblower Unit and the Information Disclosure Team. They're two areas that specialise in both the guidance and administration of sharing ATO-protected information for lawful purposes. We maintain the ATO's reporting and governance requirements specific to the disclosure and whistleblower information sharing risk. What I wish to impress upon you all is how seriously we do take the laws concerning taxpayer privacy, including yours. We operate in this country on that basis that, if we can get everybody to voluntarily comply within our tax administration system and our superannuation systems, then we just end up with a better country for it. Collecting the revenue in order to inject that back into our economy, back into our states, into our hospital systems, into our road systems. I don't need to really explain this to you. I'm preaching to the converted. It's what you deal with every day. But it is something that we take absolutely seriously because we want to ensure that all the taxpayers around the country understand that we will protect them to the best of our ability using these laws. If you could jump to the next slide, please, Ashley. So the tax whistleblower laws are still quite new, having first commenced in 2019. Some changes have been made to them over time to ensure their effectiveness is maximised, but fundamentally, their purpose has remained the same. That is to reinforce the value of disclosing wrongdoing and provide legal protections to those in a specific relationship with an accused entity. These are laws driven by culture and public interest. We are fortunate in this beautiful country that the protection of our people is taken so seriously, with care for the most vulnerable in mind. That might sound a little aspirational. I do tend to do that, but we live in a culture that aims for fairness. Kelly in our chat room, for instance, and I recently had conversations with another country's tax administration on their whistleblower regime laws. They were quite far behind us in a lot of ways, which is why they were having this conversation, because they were looking to improve theirs. But theirs is currently driven by a monetary reward for their tip-offs, for any tip-offs that lead to tax administration outcomes. So if there's audit activity that leads to raising liabilities that were otherwise underreported, and that money is collected, in this country, a percentage of the collections will go back to the person who provided the tip-off. That's not an easy system to manage when every person who provides a tip-off of tax misconduct is then calling every month beyond that to say, hey, how's it going? Have you had any outcomes from my tip-off yet? Have you collected any money, and is there any coming my way? And perhaps because of that, they are somewhat behind in managing their tip-offs. And they also have this requirement to actually manage every single tip-off. A lot of the tip-offs that we get, for instance, it's some basic information. It may not lead to an investigation, and we're allowed to close those off. They, however, have a responsibility to respond to every person who provides information about tax wrongdoing. So there's a lot to unpack in that particular example, which is a topic for another day. But let's look at how our regime protects those who disclose tax misconduct information about an eligible entity. My slides are a little bit smaller than yours. Okay, so an eligible whistleblower is someone who is or has been in a specific relationship. Those relationships are listed under the law with the entity that they are making a disclosure about. This includes, but is not limited to, current or former employees, associates, family relations, including spouse and dependents, or suppliers of goods and services, including tax and BAS agents. That's where you guys come in. The disclosure must assist the Commissioner to perform his or her duties. The disclosure must be made voluntarily and proactively. That's an important point that I'll come back to in just a moment. The disclosure must be made to the Commissioner or an eligible recipient. Those eligible recipients are also listed under law. And the disclosure must be an eligible whistleblower themselves. Now, the Tax Office treats every person who provides a tip-off as an eligible recipient. Sorry, we're on the wrong slide? No, we should be on the right slide. Still slide 2 for mine. Sorry, I saw a comment come up. And I'm looking at the circles down the bottom. So for tax agents, you now have this requirement to report back to the Tax Office if there is a false or misleading statement, so tax wrongdoing, and you have a rule that says you must do that. But there is actually some decision-making points within that process. And I know that Peter's going to go over some of that a little bit later. But because there is decision-making points within your process and our General Counsel agree on this particular point, you're still making a voluntary disclosure to the ATO. And in doing that, you are covered by the whistleblower protection regime. So just to be really clear, you are protected. So as a practitioner, you are an eligible whistleblower, as I said, and you can demonstrate that satisfaction. Sorry. You need to be satisfied, though, that you can demonstrate that you're providing professional services to a client. This is a conversation that happened just before this presentation where we were talking about just through emails. Peter was raising the fact that you do not have to have somebody specifically signed on for you. In this case, you don't have to have a client list that says this is a client of mine. Somebody has to have come to you and you're providing a service. If you come across information in that capacity that you need to pass on to the tax office, you generally should be covered. But that is a determination that you need to make in full consciousness of, do you have a defensible position? And in doing that, you would be covered by the 4 available protections. Confidentiality is the first one. So your information, in this particular case, on this particular protection, I should say, restricts the on-disclosure of information that could lead to the identification of you as a whistleblower, unless specified under an exception in the law. This obligation is broad in scope. It's not limited to information provided by the whistleblower specifically. Anything new that we come into contact with that would also lead back to the identity of the whistleblower, we need to maintain confidentiality over. So even where we find we need to send information on to have it investigated, we are under an obligation, as is anybody else who we share that information with, to make sure that we've removed any confidential information from our systems and from that escalation. Victimization. This protection prohibits anybody from causing or threatening to cause detriment in relation to an actual, proposed, or suspected disclosure. For example, an individual protected under victimization protection cannot be harassed, intimidated, harmed, or injured, including psychologically, or have their property, business, or financial position damaged. The protections apply to whistleblowers, potential whistleblowers, and the person involved in investigating or assisting the whistleblower themselves. Qualified immunity. So as a whistleblower, this protection provides you with the assurance that the ATO will not take criminal action against you or impose significant penalties against a disclosure where the disclosure includes self-incriminating information. This does not prevent a tax liability or penalty for being raised if you're involved in any of that tax wrongdoing as well and need to have new liabilities raised. And then compensation. This protection provides a civil remedy if individuals have suffered from victimization as a result of making or proposing to make a disclosure. This can be pursued through the courts by the individual, who should be advised to seek private legal advice. The ATO does not play a role in this. However, we will certainly do our best to investigate if there's been any inadvertent disclosures of confidential information made. We're constantly looking at our processes and making sure that staff have got, across the whole ATO, which is rather large, that they have got full, clear policies and procedures that they understand, so that when they're undertaking their work, if there is a disclosure made to them that whistleblower protections would come into play, that they understand how they can share information without also disclosing confidential information. Next slide, please. Okay, so this information is really important for you because although it does sound like it's a lot of ATO internal jargon, processes, things that you don't need to really be too concerned with, the day that you become a whistleblower is the day that you really do become concerned with our governance over our processes and how tightly we manage them. You want to make sure that your identity, should you have determined that you want to maintain anonymity, is protected to the fullest extent. Okay, so confidential information is defined as any information that identifies a whistleblower or information that's likely to lead to that identification of a whistleblower. Besides the recording of a person's direct identifying information, such as your name, date of birth, phone number, this also includes more obscure information that might obviously lead otherwise to your identification, such as my ex-partner who I lived with at 123 Joseph Street. Once you start to identify the relationship of the person and narrow it down to a time and place that they might have been cohabitating perhaps, then obviously the person that the tip-off is related to may find it quite easy to determine who actually provided the tip-off in the first place, suddenly placing the whistleblower in danger. Before our staff can on-share tip-off information for actioning, they must ensure any confidential information has been removed. They can paraphrase the information if it's important for the investigation, or they can redact it completely. We do have a system that was built specifically for the secured storing of information for most tip-offs. There are still some whistleblower tip-off information that might occur around the office in different ways, so perhaps the way that it was received in the first place means that it wasn't originally stored in our secured service. But for the most part, there is an external tip-off form. Majority of tip-offs come through that channel, and that goes directly into a system where nobody else can access unless they have specific security accesses to do so. It then gets managed from that point onwards, having removed the confidential information first. So just a little bit of advice for you all is that where a registered tax agent or BAS agent makes a protected disclosure about their client, this will not contravene the Code of Professional Conduct either under the Tax Agent Services Act 2009, and in particular Code Item 6, which relates to the confidentiality of client information. All right. We do at times also share with external agencies, which I'll cover shortly as to who they are, but they are listed in the law as an eligible recipient only. There are many agencies who are not eligible recipients who certainly do from time to time come to us requesting from the information disclosure team information that includes the details of the whistleblowers, and we refuse to give it to them. So even though we understand that there is a need for perhaps our law enforcement agencies to undertake really important specific investigations around criminal activity, the law simply does not support us revealing the details of an actual whistleblower themselves. We can provide, in some circumstances, the details of the tip-off that are specific to the wrongdoing, to the tax misconduct, but we won't disclose the information, the confidential information of the whistleblower themselves. Next slide, please, Ashley. Consent and authorised contacts. So consent is the act of a whistleblower providing approval to undisclose their identity or information that is likely to lead to their identification to an otherwise unauthorised entity. So, like I said, with the law enforcement agencies as the example, if the law enforcement agency comes to us directly and says we would like the information that reveals who the whistleblower is, we will say no. However, if it does seem like it is really important that they have that connection to the whistleblower themselves and they're not otherwise an eligible entity under the law, we can go to you as the whistleblower and ask for permission to disclose your information over and allow them to make contact. It's fully within your control, though, to manage that consent. If you say no, we have to abide by it. So ATO officers actioning disclosures will always consider the following questions to determine the appropriateness of seeking consent from a whistleblower. Can the work item be progressed without confidential information being disclosed? We won't ordinarily just come back to you as a whistleblower and say, a law enforcement agency needs this information, so, do you approve? It's only where your confidential information actually will support progression of that investigation. And are there any alternative sources of information that can be used that are not reliant on the confidential information themselves? Upfront consent is requested when you do lodge a tip-off form. And so during that submission, there is a box that you can tick to say, yes, I consent for my identity to be used in sharing this information for the purposes of investigating what I'm advising. This should be a feature of any new false or misleading tax agent notification forms which get built. I believe that there is a new one under development because this is quite a recent change to your rules. So the tip-off form currently doesn't specify false and misleading as one of those topics. So the external tip-off form will have the question of consent. However, lodging a request through your tax system, your tax agent systems, to ask the question directly to us or to give us the information directly won't have that specifically in there. So without an obvious consent being given up front, we simply wouldn't disclose your confidential information without coming to you, contacting you and asking you if that's okay first. If you also provided a tip-off, say, 12 months ago or 2 years ago, and we're just getting around to progressing that now, then we would also consider that if you did give us consent at the beginning, it may not be current. We may still contact you in those circumstances to say, we understand you gave us consent. However, we want to make sure that you still are of the current mind of us doing that. Do you still agree? Next slide, please, Ashley. Just a couple more to go, guys. I think, here we are. Okay, so guidance for sharing information internally and externally. Those entities or agencies that are in the law as an eligible recipient of confidential information specifically is the AFP. So as a law enforcement agency, we can provide it specifically to the AFP. They will receive your confidential information as part of that referral, and they will then have to also abide by the laws, the law as it's written for the whistleblower regime. They also have to keep your confidential information private. So whatever they do with that information beyond that point, they are not allowed to on-share it further, not without your consent. The Tax Practitioners Board, so they are now an eligible recipient to be a direct receiver as well of your tip-offs and your confidential information. That's either directly to them or it can be shared from the ATO over to them. The ACNC is also able for us to on-share with them specifically your confidential information, and the Inspector General of Taxation. Any entity with the consent, as I said, if you say to us that we are allowed to discuss your confidential information with anybody else, we can do that, as long as there is a reasonable specific purpose for it. Legal practitioners, for the purpose of obtaining legal advice regarding the operation of whistleblower provisions. So sometimes there might be a case that's come to us with a tip-off and we need to seek legal advice ourselves on the operation of the whistleblower provisions. Your confidential information may be provided in those circumstances, but we're covered by legal professional privilege in those circumstances as well. And your information might be able to be provided to a court or tribunal to give effect to the whistleblower protections, or where the court or tribunal determines that it would be required in the interest of justice. That is really limited. So it's not a situation of a matter is going to court and now your details are going to simply be revealed. The matter would need to go to court. The court would need to have a presence of mind to determine if it's appropriate in the interest of justice to reveal your confidential information. A lot of the time it's just not, because the investigation would have led to an outcome, with evidence that doesn't rely on your tip-off in the first place. And the confidentiality protection needs to be considered alongside privacy and other tax secrecy restrictions all the time. Next slide, please, Ashley. This is just an overview of the roles we have within the office, really. So there's the tax whistleblower unit, which is the area that I currently run. We have the technical advisors around the whistleblower regime. But then we have the operational aspects of this as well. So the Tax Integrity Centre are the ones who run and maintain that system that I described as to where your confidential information and tip-offs would be sitting. They administer that system. They manage and approve the request for access to that system. So they have really stringent requirements around access. And they manage the collection, sharing and handling of all disclosures. So they also do the triage work to make sure that those tip-offs, having removed the confidential information, get to where they need to go in the tax office as well for further investigation. BSL, so business strategy, business services lines, procedure owners, they have to maintain their procedures and all of their guidelines in line with our chief executive instruction that says if they are not responsible and they don't maintain those procedures, they could be liable for penalties themselves. So yes, we are a large organisation. Yes, we have a lot of branches, a lot of arms that reach out. However, all of those arms have to be aware of this particular regime, these particular laws, and the chief executive instruction that sits underneath that to tell them exactly what they are required to do, what their obligations are. And where we aren't too sure of a particular direction, perhaps it's a unique situation or a new situation, and we want to ensure that we have the right perspective of applying the law, then we also have general counsel. General counsel are excellent at providing us with advice on the ATO position, and we take those position papers and make decisions accordingly. Next slide, please. And the last one, breaches and remedies. So look, basically it is an offence for ATO staff or those where we have on-shared the information with externally to disclose the identity of a tax whistleblower or information that is reasonably likely to lead to their identification to an unauthorised third party unless an exception applies. So the starting point is no, we cannot. We only can if there is an exception under the law. Those exceptions are the AFP, the entities that I described before, and anywhere where you've provided consent. Internal sanctions, civil and criminal penalties can apply if we don't follow that line of rules. So it is something that the staff in the ATO are acutely aware of. They're aware of their personal obligation to make sure that they manage this in the right, appropriate way, because penalties can be applicable directly to them, not only to the ATO, but to them as an individual, especially if they make a conscious decision to do the wrong thing. A whistleblower who believes detriment has occurred often would notify the ATO, and we would investigate that through escalating over to General Counsel as well. So we would provide General Counsel with what's happened to date, and then they would do some investigation. But generally speaking, an individual needs to take action themselves, seek personal legal advice. We're not the ones in a matter of victimisation or detriment to provide that legal advice, because we are actually the entity that we are the entity, especially in terms of detriment, where something has actually happened to them because they believe it's the result of their tip-off, then we would be the ones who would be at fault. So we don't provide their legal advice. We tell them to get their own legal advice, and we also seek our own through General Counsel. I've only put on the screen here as well resources as www.ato.gov.au, because there is a lot of information on there for you. There's a lot of information on the tip-offs. There's a lot of information about the whistleblower regime. And in preparing to do this presentation, because it's been a little while, I went and had a look at that information as well on the website, and I feel that it's been written in a very clear way to help guide you through understanding the regime and how it applies to you. So I'm going to leave it there now and hand you over to Peter Coit.
Thank you, Diana, and thanks very much for the excellent introduction. I think there are a lot of people who are very interested in knowing how they can share information with the ATO in a way that they feel safe. Good afternoon, everyone. My name is Peter Coit, and welcome, and very pleased to see everyone joining our webinar today, which is the joint session with the ATO. Look, I'm not going to repeat the sort of areas that Diana has gone through, because the whistleblower legislation or provision that applies to TASA or the TPB essentially replicates what's already available in the tax law. It is in fact in the same section, except the ATO has had it since 2019 and ours began on 1st July 2024. So essentially the same requirements. So again, just a recap, for us, for the TASA, it commences on the 1st July 2024. Basically, you now have protection. And basically, there are key ingredients that you need to understand, which essentially replicates what the ATO does. The law extends protection to individuals who blow the whistle about a related entity, where you believe that it is going to assist the TPB in performing our functions and duties under the TASA. And just bear in mind, the TASA is really about regulating those who provide tax agent services, and whether they are operating outside the system when they should be in the system, or those who are already in the system. And sometimes clients, clients' conduct may give you some clues. Perhaps it is the agents who are engaged in some sort of misconduct under TASA. So these are the things that are within the frame of TASA. Now, I must say that during my time in the ATO, I have dealt with a lot of whistleblower, and they are extremely invaluable. They are critical to our breakthrough, and that's why the ATO and the TPB takes the whistleblower information very seriously. So think about as two layers. Tax secrecy is absolutely critical. Things that comes to the tax office, the TPB, don't ever leave the organization because it's absolutely important. But overlay that, you got your tax whistleblower regime, which gives you additional protection legally and confidentiality. We might go over to the next slide, please, Ash. So just to recap, so for whistleblower and more specifically to TASA, it is exactly the same as what Diana has said before with income tax or taxation law generally. First of all, you must be an eligible whistleblower, and I'll unpack that a little bit more as it relates to your area, which is tax agent and BAS agents. And you are making a disclosure to the TPB or the ATO, and you have a reasonable view that the information that you are going to provide us will likely to assist us in performing our duties under TASA or assist the ATO in performing its duty under the tax laws. And basically, they are very intertwined. They're very interconnected because a taxpayer's factual situation will invariably link to the practitioner's conduct or practice. The other thing I want to bring to this webinar is probably more of a practical perspective because I have dealt with a lot of whistleblowers before in my time. And the key thing is that if you're unsure, we're very happy to have an initial discussions on a no-names basis. Because sometimes just unpacking some of the things, it gives you a bit of an idea, about the context. So you don't feel that you have to release all the information to start off with. You might just want to just pose a hypothetical just to get a bit of an idea, where do you stand, and we can guide you through the process. And I find that is extremely valuable. Practitioners find it very valuable and taxpayers find it very valuable. We might move to the next slide, please, Ash. So the critical thing that most practitioners need to think about is, are you an eligible whistleblower? Now, there are some formal definition, such as, an officer, an employee. So officer are basically for companies. You got directors and company secretary and a whole bunch of people who are listed in the Corps Act. You got employees. But I think when we think about whistleblowers, we typically associate whistleblowers as those who work inside the organization. But I think in this particular instance, what it is that an individual who supplies services or goods to the entity can qualify as a whistleblower. Or an employee of a person that supplies services to the entity can be a whistleblower. And more importantly, you don't have to supply services for a fee. You can supply services even if it's unpaid and you still come within the regime. So this is critical. And this goes back to what Diana mentioned before, that you need to form a view whether this person has essentially become your client. Okay? And the client is just a shorthand of saying that, have you provided a service to this person? And the service does not have to be for reward. So if you have a client walking through the door, if they have provided with sufficient information for you to form a view that, hang on, something is not right here. Now, for you to even be able to be in a position to form that view, perhaps you have already provided some services and you may qualify as an eligible whistleblower. Okay, so I guess critical for you to think about is basically the third and the fourth dot point here, probably the third dot point, an individual who supplies services or goods to the entity, and it does not have to be for reward. Okay. So the other definitions of a whistleblower are essentially very mechanical. You've got the spouse, children, and any other entities that perhaps could be prescribed by the regulations. I might just move on to the next slide, please, Ash. Now, Diana talked about the whistleblower protection. So just to recap, the whistleblower protection gives you essentially at a high level 2 key protections. One is that your identity is absolutely confidential. Okay, that is important. Secondly, you will not be subject to civil, criminal, or administrative liability for making the disclosure to us if you are an eligible whistleblower. And information you provide is not admissible in evidence against you in any criminal proceedings. And you can't be penalized unless the information you provided is false. Okay? And also, you also receive immunity from any disciplinary action and can't be sanctioned just because you disclose information about your client. You have not breached the code. Now, to me, essentially, if you bring it down to its very basic fundamental building block of what is the benefit of whistleblower regime protection, it comes down to two things. One is confidentiality. Okay. We know that you get that in taxation law anyway, secrecy, but this gives you additional confidentiality protection. But what is critical is legal protection, i.e., if you are an eligible whistleblower, there cannot be any legal repercussion against you. So there cannot be any malicious, there can't be any civil litigation against you if you come within the regime. Okay, you're absolutely protected. So if you keep those two things clear in mind about whistleblower, right, then you would be, I guess, more comfortable in deciding whether whistleblower is the right pathway for you if you want to provide information to the TPB or the tax office. Now, bear in mind, the reason why I have very clearly stripped out those two, confidentiality and legal protection, is because sometimes you might not be too concerned about confidentiality. You might be more concerned about legal protection. Legal protection can be provided when regulators such as the TPB or the ATO compel you to provide information, such as issuing you a formal notice. So they can get legal protection that way without necessarily having to second guess whistleblower regime. Alternatively, confidentiality is important. Sometimes through the discussion, you want to make a voluntary disclosure. If we know that, we can handle that information sensitively, right? And for us, the critical thing is really not revealing ID is clear cut. What is not apparent to us most of the time is we need to know enough so that we don't inadvertently disclose surrounding circumstantial evidence that would lead you to be identified. So that the confidentiality bit is probably more important to us. So that's why it's important to understand when you're having a discussion with the ATO or the TPB, which part is important to you or both. Now we might move on to the next slide, please, Ash. So if you make a disclosure to the TPB, and bear in mind, our regime starts on the 1st July 2024, so you're now 100% covered if you disclose it to the TPB. The key thing is that ensure that in your mind that you are within one of those category of eligible whistleblower. And secondly, you think that the information is going to allow us to administer TASA properly, right? So TASA is the key word here for the TPB. Tax law, I think that's a key word for the ATO, but just be very clear. Okay. Now, if you make a disclosure to us, we do have our complaints form. We encourage you to provide as much information as possible, simply because the more information you can provide us, the more targeted we can be. In fact, we don't really expect you to do investigative work. That is our job. But if you already have the information available, we would love to have them. Secondly, having the ability to have that confidential discussion with you is critical. I have many countless times where being able to actually have that confidential discussion with the potential whistleblower gave me much more information and context than just a simple form, right? So if you can provide as much information as possible, but again, only based on what you have, you don't need to do your own investigation because that's our job, okay? Now, we might want to move on to the next slide, please, Ash. So I guess what happens after you made a disclosure, Diana has kindly outlined how the ATO manages information. Our system is very much tied in with the ATO ecosystem. We manage it in the same way as the ATO. We treat it very seriously. You will get an acknowledgement email with a reference number. That way you got your own records. When we get your complaints, one of the myths that we would like to clear up or bust is that a whistleblower information does not automatically lead to an investigation or termination. That's absolutely not the case. When we get information in from a whistleblower or from any sources, including just a general tip-off, we would always do a lot more work. We need to compare it and analyze it against our intelligence that we already have, as well as any other information that might be held by anyone else in the Commonwealth. So we will do some analysis just to get a bit more, I guess, clearer picture of what's actually happening, because if we happen to come across, well, not just one whistleblower, but there's been like 5 other similar complaints, some are whistleblowers, some are voluntary, tip off, then that tells us a pretty clear picture of what's happening. So be assured that we will do a lot of our own internal analysis before we actually take the next steps. Now, even if we decide to take the next steps, we are always extremely discreet, especially when it's whistleblower, right? Remember, the key word here is that we absolutely do not want where people's identity can be identified just because someone in the know can piece together the circumstances in which action was taken. So we're absolutely very sensitive to that. So that's why if you provide us with as much detail as possible, as well as what your concerns are, we can manage around that. Okay, so we take extreme care if we were to make inquiries or make contact to ensure that the circumstances don't identify you. And examples could be that we might leave it for a period of time before we make contact, right, with a person of interest. Or the way we go about making contact would not lead to the fact that someone has dobbed them in. So we are very discreet. Okay. And probably the other thing I would probably add is that as a whistleblower, sometimes you're anxious. You would like to know what's the outcome. Has anything happened? Unfortunately, we are, again, due to the tax secrecy provisions, we don't typically, we just can't provide feedback to the whistleblower as to what's happened to it, right? But please rest assured, something has been done. It has been actioned. And perhaps the only time you might see something that is public is because it's public information, because certain individuals might wish to challenge our decision. It goes to court. But if they simply just, if it's tax office, they pay the tax and whatever interest penalty they're up for, you will never hear about it. For the TPB, if we terminate, you see it. But sometimes we might take other actions which might not be as visible to you. But please rest assured, things are happening. So I might just move to the next slide, Ash, please. So having talked about whistleblower, I just want to quickly talk about how does that tie in with breach reporting. So with breach reporting, you might recall this has come in and is relatively new since the 1st of July 2024. I won't attempt to go through any detail because we have other webinars where we've gone through this before. But fundamentally, since the 1st of July 2024, as registered practitioners, you now have 2 obligations mandated by the law. The first one is self-reporting. If your practice has, if there's been a significant breach in your practice, you have to self-report. And secondly, this is reporting another registered practitioner. And I emphasize the word registered practitioner. This is the one that's probably more relevant to you in the context of whistleblower. That is, how does the breach reporting overlap with mandatory reporting of significant breaches by another tax practitioner? So a few key things. You must have a reasonable grounds to believe that there's been a significant breach. So that will be your first cue. Now we might move to the next slide, please, Ash. So just remember, breach reporting cannot be made anonymously. You need to identify yourself because it is an obligation under the law. But the good thing is that because you're obligated under the law, under the mandatory breach reporting of other registered practitioner, because it's a legal requirement, you are automatically protected under legal. And hence I go back to the 2 points I made before about whistleblower: confidentiality and legal protection. So if confidentiality is not important to you, then legal protection can be given to you because you are reporting it under the mandatory breach reporting of other practitioner, but they must be registered. Okay. So keep those things in mind as to which pathway do you think works best for you and what suits you best when you are thinking about reporting to the TPB. And again, whistleblower, the key point is that what is your relationship with the person whom you are blowing the whistle on, right? If it is a client, think about, is it service But if it's in relation to another registered practitioner, I'm not sure if you could quite easily fit under the whistleblower regime because you haven't provided service to the other practitioner, but you might still get legal protection under the mandatory breach reporting. That's why they were introduced. Okay. Now I might move on to the next slide, please, Ash. Now, I just want to quickly touch upon this topic called false and misleading statements. And I'm not proposing to go into chapter and verse what false and misleading statements are about or the nature of the obligations, but it's more to give you an introduction, but also to tie it back to how does it tie in with whistleblower regime and the mandatory breach reporting. So false and misleading statements. This is a new code determination. It commenced on the 1st of January 2025 for large practitioners who's got 100 employees or more, and it now applies to everybody since the 1st of July 2025. So basically, there are two aspects to false and misleading statements. The first one is you, i.e. the focus is on you as a practitioner. You must not make, prepare, or permit, direct someone else to prepare statements that you know or ought to know is false and misleading. Okay? And this applies to statements that, you're involved in that is provided to the TPB, the ATO, or another Australian government agency. So it's not just tax. Okay? So the nature of the obligation is really one about truthfulness and integrity. Now, of course, we know that no one goes out of their way to provide false and misleading statements. The second one under the false and misleading statement is probably the more common one that arises. That if you have discovered subsequently that a false and misleading statement has been made or caused to have been made, then you are now required to take certain actions. Okay? So if it's been made to the ATO or TPB, you are now required to take certain actions. Now, if you basically have a reasonable grounds to believe that the false and misleading statement is material. Now, remember, we're not talking about every single statement must be true, but if it's material, if that false and misleading statement is material, and you realize that that statement has been made to the ATO or TPB, then you must take certain steps. Now, the steps you need to take are essentially within 30 days, you need to basically notify the TPB or the ATO, it doesn't matter. And basically, you also need to tell us whether you have actually informed the client that these statements were false and misleading, and your advice is that they need to correct it. Now, you don't need to follow through whether they do in fact take the action or not, but we just need to know about it. Okay. Now, I might just pause there, and I might just ask Diana to maybe provide some comments about this aspect about false and misleading statements before I continue with this presentation. Diana?
Thanks for that, Peter. Just trying to find my slides. I don't have the same access on the screen as what everybody else does, mostly because I had to join with my iPad. But look, the first thing you need to be aware of, obviously, is to determine that you do need to actually report something. I found in reviewing the TPB documentation that guides you through that process to be very, very useful. So I suggest that if you aren't too sure, that you go and have a look at that particular webpage and all the details contained within it to assist you to make that determination. Now, within the ATO website, there is a section on how to notify us, specifically relating to the false or misleading statements. Now, I guess what's interesting to me is that we've spoken today about the secure nature of the system that we built for you to be able to provide tip-offs to us, not just you, but anybody in the community who needs to provide a tip-off. That system is not currently being automatically used for you because consultation with the tax agent community said that you wanted to use the channel that you already had to ask questions of the ATO. So you, in going to that How to Notify Us section, you would download the tax practitioner assistance form, and you need to follow the prompts on this particular webpage to describe the matter that you are reporting as false or misleading, and it will get to where it needs to go the fastest. And it'll also then allow us to be able to secure down your confidential information and treat it appropriately. So you complete that form and that comes through to us. We are currently finalising a secure inbound channel for you, though. I believe that is also being built. Our webpage at the moment suggests that as soon as that's available, it will be updated on that webpage as well, and you would be notified. But at the moment, outside of the tax agent form, you still do have available to you the external form on the ATO website for lodging a tip-off. It's available both on the ATO website and the TPB. For whatever reason, if you decide that you would rather use that form, then please go ahead and use it. The Tax Integrity Centre will make sure that your matter is routed over to where all the false and misleading matters get dealt with. And again, your confidential information will stay private that way. Something that I wanted to also just highlight to everybody is that everybody who does lodge a tip-off through the tip-off form, they automatically receive the protections of confidentiality. We don't go through, because we get so many tip-offs that sometimes aren't related to actual tax misconduct. People tend to lodge things like child support matters and stuff through that form too, just because they were misguided. But every tip-off that comes through to us receives the protection of confidentiality without assessment. So we will make sure that your information is locked down regardless of, whether you feel you meet the requirements or you don't meet the requirements. You will at the very least upfront get that protection given to you as well. But yeah, back to you, Peter.
Thanks, Diana. So over to the next slide, please. Ash. Thank you. So again, just to recap, when we are referring to the false and misleading statements that you might have inadvertently made, as I said before, no one sets out deliberately to make a false and misleading statements. But if you have inadvertently made a statement that you realize subsequently that this is a significant, this is material, it was false and misleading, then you have an obligation to report it. Now, the key takeaway is that you can report it to the ATO, report it to the TPB, it doesn't matter, you do it once, that's fine, right? Now, the other thing that I want to also highlight is that, next slide please, Ash. The other thing I want to highlight is that when you have uncovered that you might have assisted or inadvertently prepared things which are false and misleading, and you have made the assessment that this is material, you do your reporting. It may also be a significant breach that you also have to report. Whilst there are two separate obligations, we don't expect you to report it twice, right? So report it once, that is enough. Okay, so you can actually satisfy both obligations when you report it once. So again, false and misleading statements is really about what you might have inadvertently done because you're unaware of it. The first thing is that you need to report it to the TPB and the ATO. Doesn't matter which channel you use because we do refer it back and forth. Secondly, think about breach reporting. If it's a breach reporting, you have to report it to us as well. But I guess in a way, if you report the false and misleading statements to the TPB, because you're also doing it under the significant breach, you report it once and never satisfied your both obligations under TASA. And the third thing is that, do you think that you need to take steps to advise your clients that this statement that was prepared previously was false and misleading, and you advise them what they need to do, but that will be the extent of it. You don't need to follow through. Okay. We might move to the next slide, please, Ash. So again, just to recap, breach reporting and false and misleading reporting could be satisfied by just the single reporting. So very happy for you to report it once to us, and that should be it. I might then go to perhaps the next slide, please, or maybe the last slide, Ash. Next couple of slides. Next one. Yep, that's it. So again, I just want to bring it all together. First of all, if you think about it, right, breach reporting for practitioner is about conduct of registered agents, whether your own identified self-breach because employees might have gone rogue in your practice, or the conduct of another registered practitioner. So it's basically practitioner conduct. False and misleading statements, if I can sum it up in a neat way, it is your involvement, i.e., you have inadvertently helped prepare or miss something that caused whatever was presented to be false and misleading. So it's about your own conduct. And finally, when you look at the whistleblower regime in the context of as a practitioner, it could be related to both the client, i.e. the taxpayer, and you or another practitioner. Okay? So whether another practitioner comes under whistleblower or not depends on, whether you fit into the definition of eligible whistleblower, right? And the key point is that did you provide service or goods to the other practitioner? And most of the time you are not going to be providing service or goods, right? So in a nutshell, whistleblower is really about your own practice as well as the taxpayer's conduct. The last thing I want to just to remind you is that the disclosure, you absolutely have absolute protection from legal professional privilege. In other words, if you have legal advice, please don't disclose it to the ATO or the TBB, because otherwise you might inadvertently waive privilege. That is yours to keep. So these are the things that you want to think about when you're thinking about disclosure. I might just stop there in the interest of time, and I hand it back to Julie.
Thank you so much for that, Peter, and thank you to Diana as well. They were really great presentations today. Now we have kind of run out of time, but I would like to just ask you one quick question each, if that's okay. So the first question I've got is for you, Peter, and it's just asking how do things work within a practice when an employee of a client discloses to their practitioner? Is the practitioner allowed to speak to other employees involved in doing the work for that client?
I think we've got to be very, very careful when we think about that, because remember, the employee of a client is essentially a whistleblower. So you are now in receipt of whistleblower material, and you really need to think about how you handle that. And I would say that exercise extreme care. Start with a position of no. The people you should be talking to are the ATO and the TPB. That will be my first starting point. But I might just see Diana has got any other thoughts.
No, I'm with you, Peter. I think extreme caution when stepping forward.
Excellent. Thank you both for that. And Diana, just a question that came through for you earlier in the presentation today, and it was asking if I terminate my engagement with a client before I lodge anything because the client refused to comply with substantiation rules, am I covered by whistleblower law, and do I need to report this?
It's a very good question, because I would say, quite often a tax agent might be speaking to their clients about the fact that they need to change their reporting. They need to correct something. Perhaps that client doesn't want to correct it, and maybe they might say, well, we're no longer connected. You're no longer going to be my tax agent. I can see that would potentially happen in the real world. I expect that, yes, you would be still covered, because the advice that you provided at the time was at a point in time when you were the tax agent. So I think that the false or misleading conduct that you are reporting on is covered by the whistleblower provisions.
Mm-hmm.
You could certainly ask that question of us, though, prior to blowing the whistle. You could come to us with a general inquiry to say that you do have somebody that you would like to report on, but they're no longer your client. We could certainly ensure that we have sought advice from general counsel on our side of the fence to be reasonably certain that, yes, you would be covered. I think what's really important to understand about law in general is that we have them, we apply them, but until they're tested in court, we don't always know the exact position that a court would take. So we do need to, even where we're fairly confident in our senior technical roles, we know what we're doing. We also know that a case like that hasn't gone to court. It hasn't been tested yet. So we would always seek support from general counsel on our side of the fence for you prior to you perhaps becoming a whistleblower.
Great, thank you for that, Diana. And I think that's quite reassuring for the people online today. So we might just leave it there just because we've reached 3:30. I'll just give some quick information on how to stay in touch. So if you wanted to keep up to date, please jump on our website at tpb.gov.au. You can also jump on the ATO's website at ato.gov.au. Also follow us both on LinkedIn and Facebook. And we also have a YouTube channel that you can subscribe to where you'll receive notifications of any new video content that we upload. And we have a comprehensive library of all of our webinars available there that you can watch at your leisure and still claim your continuing professional education for. We also have our monthly newsletter, which is TPB e-news. So I highly encourage you to subscribe to that to get all the latest information. I just wanted to say a big thank you to both Peter and to Diana for their insights today. It was very valuable hearing from you both. So thank you for that. Also, thank you to our chat assistants there today, answering all of the questions as we went along. I think you got through quite a lot there today, so thank you so much for that. And then just finally, before we do wrap up, we'll be launching an exit survey. So we would really appreciate it if you could take the time to complete that. It's very quick, only a moment of your time, but it's really great in terms of letting us know if there's anything that we can improve on, and also any topics that you might want to hear about from us as well, just let us know. So thank you everyone for joining us today, and we hope that you enjoy the rest of your day. Thank you.